start. In a case where the Bombay High Court had directed Kolhapur Municipal Corporation to acquire an unusable land under the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 and compensate the landowners. The bench of Mr. Shah and B.V. Nagarathna J.J. has held that when land is found to be unsuitable and unusable for the purposes for which it has been reserved, corporation cannot be compelled to pay a huge compensation for such a useless and unsuitable land. Stop. The dispute is with respect to the land at measuring 3 hectares and 65 acres in Kolhapur. Stop. The development plan for the city of Kolhapur was sanctioned on 18/12/1999. Stop. Different portions of the land in question were reserved in the sanctioned development plan for various public purposes, namely parking, garden, extension of sewage treatment plant, etc. Stop. By resolution dated 18/2/2012, the general body of the municipal corporation resolved to acquire the said property, and accordingly on 17/4/2012 a proposal was submitted by the municipal corporation to the state government for compulsory acquisition of the subject property. Stop. However, the subject land is flood affected through which a revutal named Jayanti Nala passes, making it unsuitable for the public purposes for which it was reserved. Stop. Further, it was argued that unless and until the substantial development is carried on, the land in question was not usable at all. Stop. The reserved area is coming within high flood line, and every year for a period of 15 days to 1 month the said area gets flooded during rainy season. Stop. As the land in question was not acquired and or used for the public purposes for which the same was reserved under the sanctioned development plan, the original landowners served a notice under section 127 of the Maharashtra Regional and Town Planning Act 1966. Stop. It is also to be noted that the reservation had lapsed as a mere resolution being passed by the general body of the corporation to acquire the land and sending a letter to the collector to acquire the land without any further steps being taken under the Land Acquisition Act, namely no declaration under section 6 thereof being issued within a period of 1 year from the receipt of the said purchase notice would result in the reservation as deemed to have lapsed. Stop.